Introduction. In simple words, a tort is a civil wrong. When an act committed by one person harms another person or injures his or her legal rights, it can be classified as a tort. On the flip side, omission to perform any act can also constitute a tort if it results in harm or injury to another person. The person committing the tort is known as the tortfeasor. In suits relating to torts, it is very essential for the injured party to show that the harm or injury caused to him or her has a direct bearing to the cause of action. And like most areas of law, the law of torts is not codified, i.e., it is not derived from a statute. It is for this reason that tort law is often referred to as judge-made law. Etymology. The roots of the word tort lie in the Latin term tortum, which literally means to twist and implies twisted or wrong conduct. Definition. Salmond, an eminent jurist, defines the term as a civil wrong, independent of contract, for which the remedy is an action for damages. For essential elements of a tort, 1. The existence of a duty of reasonable care to be observed towards others. 2. The wrongful commission or omission of an act. 3. Causation of actual damage or infringement of legal rights due to such wrongful commission or omission. For the remedy. Existence of a duty of care. The law imposes a duty on every individual to observe and maintain a reasonable standard of care when performing any act which may potentially cause harm to another person. It is not necessary that the injured party and the tortfeasor have a direct connection for the duty of care to exist. Rather, the duty is imposed by operation of law. Wrongful commission or omission of an act. For any commission or omission to be recognized as a wrongful act, it must be so regarded by the law. An act that is in violation of a law can be suitably classified as a wrongful act. A wrongful act must also cause actual harm or result in a legal injury to another person. Actual damage or legal injury. For a wrongful act to constitute a claim for tort and give rise to any liability, the claimant must have suffered any actual harm, loss. Remedy. Wherever there is a wrong, there is a remedy. Granting rights without the provision of remedy in the case of a breach of those rights would be quite pointless. Similarly, the law of torts also prescribes certain forms of legal remedies for injured parties that are awarded by the courts.